All right. Good afternoon, everyone. Welcome to our 3 o'clock briefing, Advancing Justice with Lessons from Psychology. We have 3 speakers on our briefing today. They are Tess Neal, Assistant Professor of Psychology at Arizona State University, Ira Hyman, Professor of Psychology at Western Washington University, and Sarah Brown-Schmidt, Associate Professor of Psychology and Human Development at Vanderbilt University. So we will hear opening remarks from each of our speakers, and then we will take your questions. Thank you.
Hello, my name is Tess Neal, and I'm an assistant professor of psychology at Arizona State University. I'm here today to tell you about a new paper that we've just published now, which reveals a common but hidden problem that affects people at the worst time in their lives. Imagine that you or someone you love becomes involved in an unexpected legal issue. Perhaps a divorce is filed and a decision about the custody of shared children will have to be made. Or after a bad car accident, the victim in the other car develops symptoms of post-traumatic stress and sues you for emotional harm. Or even worse, you witness your loved one being threatened by a stranger. You act to protect your loved one and you end up killing the stranger. Your thoughts, your actions, and your history will be examined by the court, all of which will weigh into the punishment you receive, including whether, how long, and where you will serve a criminal sentence. For help in making decisions like these, the court often turns to mental health professionals. Each year, hundreds of thousands of psychological assessments are conducted and used in court to help judges make legal decisions that profoundly affect people's lives. The professional field that offers psychological assessment services to the court is called forensic psychology, and it's been growing steadily over the last few decades. Over the same period of time, there's been a major increase in the creation and marketing of psychological assessment tools. Psychological testing is a big business industry. There are thousands of different kinds of psychological tests, and they're often expensive to use. People might assume that psychological tests sold by reputable companies are based on strong science, but this assumption is problematic. To be clear, there are some excellent psychologists doing science-based, scientifically informed, evidence-based assessments. However, many others are not. We know this because we looked in depth at the psychological tests that are used in legal settings, and we also closely read actual legal cases that included this kind of evidence. Our new finding in this paper is that there is substantial variability in the scientific underpinnings of psychological tests. Although some of these psychological assessments have strong scientific foundations, many others fit criteria the U.S. Supreme Court has described as junk science. For example, we were able to clearly identify only 40% of these tools as having generally favorable scientific properties. This is a problem because bad psychological evidence may contribute to unfair legal processes and unjust verdicts. The problem is made worse because the courts are not separating the good from the bad. Even though courts are required to screen out junk science, one of the major findings of our paper is that nearly all psychological assessment evidence is admitted into court without even being screened. So what can be done to fix these problems? In our open access paper, which is free to the public at the publisher's dedicated website and also on my own website, we offer concrete advice for members of the public interacting with psychologists in the legal system, for lawyers and judges, and for psychologists. For the public, encourage your attorney to scrutinize psychological assessment evidence. For lawyers and judges, investigate the methods of psychological expert witnesses using easily accessible and credible sources, which I'm happy to answer questions about. For psychologists, for the mental health practitioners, be more diligent in selecting your tools, and for the scientists, engage in more critical review processes before taking your new products to market. We believe all these things have the potential to make the legal cases in which psychologists are involved more fair and just. I want to say a quick thank you to my 4 collaborators, Chris Lebogan, Michael Sachs, David Fagman, and Kurt Geisinger, who propelled this project forward, as well as to the 34 graduate students, law students, and postdocs who made this project possible. I have a 1-page summary with contact information if anybody wants it. Thank you.
Hi, I'm Ira Hyman. I'm a professor of psychology at Western Washington University, and I'm going to talk to you about really the very nature of what it means to be a potential, and notice I say potential witness to a crime or an accident. Most people, as we go through our day-to-day experiences, we're not sitting around watching for crimes or accidents to happen. And what we've been interested in our research recently is how that sort of not being prepared and probably doing something else is going to impact the awareness and potential memories that eyewitnesses may develop. In our line of work, what we basically do is, we'll see if I, there we go. What we basically do is we show people a very complex event. In this example, what we have is a lot of people passing through a hallway. Some of the people we have watching this video, we tell them to actually watch for a theft, which you can see the moment of the theft there with the young man stealing the bright pink flowered backpack. Other people, we ask them just to watch the video, and then some people we actually give a separate task to, which is much more common about what we're doing. We're not just sitting around watching, and we're not sitting around watching for crimes. For people who are given something different to do, very few of them notice the theft at all. Even people who are just watching without any basic goal are unlikely to notice the theft. People who are watching for a theft, which is not something we typically do notice the theft, but the basic problem as well is that in a complex environment like this, it really disrupts the ability to identify the perpetrator later on when shown a lineup. More so, the person who's sitting over there at the table is in the scene for a long period of time, and people are very likely to identify incorrectly that innocent bystander who didn't actually commit the theft. So that we set up things like this for witnessing a theft, but the situation where people aren't actually watching for it. We've been doing similar work with witnessing or potentially witnessing traffic accidents as well. In this example, we have a long dash cam video that participants watch. We either tell them to watch for an accident, or we just tell them to watch the video as though they were driving through traffic, and we'll ask them questions about it. Or we tell them to do something different. In this case, we ask them to count school buses, of which there are a grand total of 2 in the entire video. You see both of them on the screen right there. Most people eventually notice that an accident happened, but they're very unlikely to notice it at the beginning of the accident, so that they catch the accident after it occurred. When we ask them about the cause of the accident, however, even though they didn't see the beginning of the accident, they nonetheless give you an answer to the question about the cause of the accident. Typically an incorrect cause of the accident. They blame the white car for speeding because they didn't see the black car that turned into it and hit the back end of it. And so we see these sorts of examples relatively frequently if we start to do research on these things where people are not actually watching for a crime or an accident, but when they're put in a position where that occurs, they may still fail to see it, but nonetheless ask questions. This matters for lots of police investigations potentially, and also for legal settings, because if people are asked questions about something they didn't see, although they saw maybe the tail end of things, they will fill in the blanks with other information, potentially and very frequently erroneous information. So that one of the major contributors possibly to eyewitness memory errors is actually an attention failure at the beginning of the issue. Going back to early Supreme Court decision in 1972, Neal versus Biggers, there's a sort of requirement when you're evaluating witnesses to assess the attention of the witnesses, whether or not they were attending to the event in question. That's almost never done and never part of the police interview process. And police expect people, if they were there, to have seen it. And what's more, we all expect ourselves to have seen it. If we're there and there's an accident, we expect that it's going to grab our attention, that we're going to notice it, but much more frequently, we're going to fail to notice those sorts of things. Thanks.
I'm Sarah Brown-Schmidt. I'm Associate Professor of Psychology and Human Development at Vanderbilt University. Tomorrow, I'm going to give a talk about memory for conversation as evidence in legal settings. And I'll review work that comes from a review of the literature as well as recent studies in my lab that afford 3 primary conclusions about memory for conversation as evidence. The first is that memory for conversation is limited. So if you bring people together and ask them to have a conversation, and then after breaks of anywhere from 5 minutes to 5 days, people can recall in detail specific words, anywhere from 0% to 40% of what was said. Factors that affect how much can be recalled include the delay, so more can be recalled immediately as opposed to after a long delay. There's also an effect of like what level of detail you want. So if you want memory for just generally speaking what was said, that tends to be more complete than memory for word details. There's also some interesting evidence, but I would say it's emerging, that memory for inappropriate content tends to be better remembered. Yeah. So the second general conclusion is that people are about twice as likely to remember what they said themselves as compared to what the other person said to them. In my own lab, we find this extends to if you have a game with a person and you talk about various game pieces, you're way more likely to remember what you talked about as compared with what the other person talked about. We even see this for online communication. So if you go onto Instagram and browse through an Instagram feed, you're way more likely to remember the Instagram posts that you commented on compared to the ones you just viewed. The third finding is that despite these limitations of what's recalled, accuracy is pretty good, and there's a nice historical example of this. So in a famous analysis of John Dean's memory during the Watergate hearings, this is work by Ulrich Neisser, he looked at Dean's testimony to the Senate for memories of a conversation that Dean had with Nixon. And what's interesting is you're able to compare the testimony about this conversation with the Oval Office recordings of the very same conversations. And in a particular piece of testimony, it was about an event that occurred on March 21st, 1973. Dean testifies about this conversation about $1 million blackmail demand. It's a pretty juicy conversation. And Dean testifies about it, and he's absolutely correct. They had an extended conversation about $1 million blackmail demand. However, he misremembers the date, and he also misquotes Nixon. And so that kind of illustrates both how people can be generally right about what was going on, but miss key details. So what does this tell us for implications for law? Memory for conversation is much like any other kind of memory. It's your personal record of your personal experience from your own perspective. So if two people came together and they had a conversation, it's entirely possible that they could walk away with completely different ideas of what was said simply because of these memory biases. So if you were in a dispute with somebody and memory for that conversation was relevant, it's totally possible that you would have different memories of what was said. The other finding is that's relevant possibly for law is if the memory was taken immediately after that conversation took place, perhaps in contemporaneous notes, the scientific evidence would say that that memory is likely to be more complete as compared to if the person was trying to recall that information after some period of time.
Excellent. Okay, now we'll open it up to your questions. If you have a question, please raise your hand. We'll bring you a mic and kindly state your name and affiliation before your question. First one is in the back here.
Hi, Robert Frederick, American Scientist Magazine. This question is for Dr. Neal, Tess. It sounds like there's quite a lot of injustice that has happened in the past. Will your research be aiding lawyers to try and look at old cases and try and bring them back up for reevaluation?
So I don't have any data about whether these have actually contributed to injustice. I am sort of curious to see what happens after this paper comes out and if people start paying attention or looking into this, what kinds of cases might be uncovered. And I think there's potential for that kind of thing to happen, but I don't know any specific cases.
Tess, when you did the analysis of the psychological assessments and you saw the flaws leading you to understand the nature and significance of the errors, what did they look like? What was that variability and what were the signals of concern?
So we started by looking at what the Supreme Court defines as the standards that judges are supposed to look at to determine whether evidence should be admissible or not. And there's four, the Supreme Court has said this, and then it was codified in the Federal Rules of Evidence as well. There's four things that judges are supposed to look at, in addition to other things that they might want to. Things like, has this technique that the expert is trying to use, has it ever been tested before? What the method of the expert, whatever they're trying to testify about, has it been generally accepted in that expert's own scientific community? Do other people think that this is legitimate? What's the error rate associated with the technique? And has it ever been peer reviewed? And so we looked at, those were kind of the guiding criteria for what we looked at in our analysis. And so we looked for evidence of testing. Turns out for psychological tests, almost all of them are tested, so that looks really good. But then when we get into general acceptance, we see quite a bit more variability. There's a lot of tools in use by some people, by some clinicians, that the field would say is not acceptable for use. That data is in the paper. And then we also looked at these review sources for the psychometric properties of the various tests that we know are in use in legal settings. So we looked at things like error rate and things like the reliability and validity of these tools. Can they measure what they purport to measure in a way that's valid and should be claimed as such? And we found quite a bit of variability there. So only 40% of the tools that we looked at really had strong psychometric properties. A lot more had, so 40% had strong. There was another chunk of them that had mixed properties, like sometimes they look good depending on the context, and then there's a whole nother chunk that just have poor psychometric properties.
Is that because the people who are writing the tests need different kinds of training and insight and perspective, or what's going on there?
Yeah, I think that's a great question, and I don't really know the answer to why this is happening. I know, I think part of the issue is that this is a big business. So there's some big companies out here that are publishing these tests and sort of looking for the next, the next test that they might be able to publish. And I think there's some tension between scientific development and making sure a tool is right before it goes to market. I think that's one thing. Another thing is that, I'm a practitioner by training too, and nobody ever, I'm trained. I know I'm supposed to go look at the psychometric properties of a tool before I decide to use it, but I did not have a good concept that some of the stuff that's being marketed to me is not a strong tool. And I don't think that many other people are even aware either, many other clinicians in practice. So I hope that partially this will be educating everyone that everybody needs to be more scrutinizing.
Great. Okay, we have a question here and then over there. Yep.
Hey, I'm Julia Köppe from Der Spiegel in Germany. And I have a question to you, Tess. Do you know whether these tests are used abroad as well or only in the US?
There are definitely tests that are used abroad as well. Then one of the next things I want to do is work with people in other countries. I have some collaborators in Australia where we're starting to work on some of this as well. And definitely this is a worldwide situation. They're also used in Europe. There are German forensic psychologists who are testifying in court using tests.
This one's over here.
So judges have, Tom Keenan, Business Edge, judges have two decisions to make. One is the evidence admissible? And then as to weight, do you have any indication how much weight is being put on these? Is there a way to measure that?
Yeah, so judges definitely have the admissibility decision to make, and they make that decision in the absence of a jury, right? But the weight question could be for the judge to weigh, or it could be for a jury. And so if a lot of the cases that we read, some of the commentary that judges would write was that, yeah, we're going to go ahead and admit this even if it was challenged because these issues should go to the weight and not to the admissibility. So that was kind of a common refrain that were in the opinions of the judges. But then in terms of whether the jury is weighting this information or the judge, I think it depends on, there's a lot of factors at play in any given case. And if this information about the validity and reliability of the test comes up and jurors or judges are aware of how the psychometric properties of a given tool look like, then they might be better able to weight them appropriately.
On a much lighter note, do you know the television series Evil? It's about forensic psychologists, and the protagonist loses her job. Do you know it? It's the forensic psychologist loses her job because the district attorney wants a particular outcome.
Interesting.
We have a question in the front row. Special thanks to our mic runner for so much good running.
Hello, Mohammed Mansour from Egypt. What I understand from this that testimony is a matter of point of view. Is it right?
That
Testimony,
testimony.
yeah, is a matter of point of view.
Yeah.
Well, like memories are encoded by an individual, and the way that a memory is encoded by a person is going to be based in part by their own personal experience.
Yeah.
And so two people may have different memories of the same thing.
Okay.
Would you agree?
So,
Yeah.
is this make that testimony a wrong way that should be dismissed from justice system?
Repeat your question again,
Yeah.
of course.
This make that testimony process when I go to that to testimony in the court. Should this is this make the testimony a wrong way that should be dismissed from the justice system
So
as it's a point of view?
I'm going to give a maybe answer. And in part, I mean, we do know that erroneous eyewitness identifications are probably the primary contributor to false convictions. And when we're relying entirely on eyewitness identification of a stranger, it can be very problematic. We know, as Sarah told you, that memories for the details of what happened can be erroneous as well. However, memory for the general gist of a lot of events is going to be much more accurate for the general ideas of what happened. And there may be some disagreement about some of the details. And if the question is what's in the details, then it can be problem, in a court proceeding. If the question is about the general nature of the situation, it can be much more reasonable to use in that sort of a situation. The trick is knowing or having any confidence in the witness's ability to tell you when they noticed something or when they became aware of something and when they're actually giving you memory versus when they're giving you things that they filled in otherwise. I don't know if you want to respond as well, Sarah.
Yeah, I would agree with what you said. I think another thing I would add in the domain I work in conversation, an interesting thing one could do is look to see how similar two people's memory are of the same thing, and that may be an indicator of accuracy, right? So if some of the details people disagree on, but there's another set of details that people are consistent across viewers, you could say, that might be a cue that might be a more accurate memory. Yeah, how that would play out in an eyewitness case, I don't know. I think that would be a super cool question to look at.
Another question in the back.
It's for Dr. Brown Schmidt, Robert Frederick, American Scientist magazine. There's been a lot of talk in the news lately about transcripts, and as well as people relying upon, as they call it, contemporaneous notes, where they might have had a conversation and then got back to their office and written a record of it. Do you have any sort of sense of what might be lost in a non-transcript type transcript, if you like, to not put too fine a point on it, and as well as sort of, is there any kind of linear relationship or any kind of relationship in terms of amount of time that's passed and amount of accuracy that's lost?
So the literature to date says that the more time that's passed, the less likely details will be recalled accurately and completely. But exactly what that function is relating time to detail is unknown and is worth knowing, absolutely. There are a number of features of language that are not necessarily expressed in writing. And so, when I talk, I move my body and I use prosody. Much of that detail will be lost. Another kind of related to that, something that is of great interest to linguists is the distinction between the literal meaning of what you say and then its implicature. So the classic example is, can you pass the salt? The literal meaning is an informational question, but that's not what you're saying. I am asking you to do something for me. And so the study of pragmatics talks about that kind of meaning. And so there are a number of aspects of meaning that may be distinct from the meaning I would generate in the moment when I'm understanding you, as opposed to what a third-party reader may understand from a transcript.
Question online.
This question is for Dr. Neal and Dr. Brown Schmidt from Nicholas Luco. He's with El Mercurio in Santiago, Chile. He asks, were the errors significantly more frequent depending on age, education, or gender?
In the literature that I'm aware of, has not taken an individual differences approach. So in order to be able to characterize differences between individuals based on indexical characteristics like age, gender, or SES, one would need to have reliable estimates that accurately characterize individual differences between persons and these abilities, and that has not been done in this my literature. Yeah.
I don't know enough of a good answer to that question to be able to answer it well.
Good answer. So, on that note, Sarah, when you said that we can recall up to 40% of memories, what do you know more about what the sample size or what age or the numbers of people that was studied in? And is there any plan to look at how that might change in a society where we use a lot of technology that could be changing our brains and the way that we remember?
So for the first part, there is this topic was of interest in the late 70s and early 80s, and there's a small body of work looking at that. And I don't recall off the top of my head the sample sizes they used. In my own lab, as reproducibility of science has become more important, we're repeating those studies right now in order to have an open science approach to that work so that the data can be shared freely and so people can calculate these various things that folks are asking questions about. So I don't know the details there. With respect to how use of media might change cognition, there are a number of people on that question, and I have read papers arguing that it does, and I've read papers arguing that it doesn't. So I would say that's an emerging enough research question that we probably don't know the answer to it. Yeah.
Yep. Yeah, question here, sorry.
My name is Alok Jha. I'm from The Economist. Dr. Neal, can I just ask you to flesh out a little bit more about the psychological tests that you mentioned? I mean, this is maybe in your paper, so sorry. What kinds of psychological tests? What do they do in the courtrooms? I mean, are they tests that the witnesses themselves take? Just give me some color about what these are, and then which ones are the ones that tend to be not so good?
Yeah, that's a great question. There's a lot of variability here. There's a lot of different ways in which the legal system has questions about features of people who are coming before the court. So things like the legal question is sometimes synonymous with what a psychologist can answer, but oftentimes there is a leap, an inferential leap. So that the legal question that's most on point with what a psychologist can answer is eligibility for capital punishment. So the U.S. Supreme Court has said if somebody is intellectually disabled enough, they are ineligible for capital punishment based on the Eighth Amendment against cruel and unusual punishment. There is a psychological test, good ones, IQ tests, that have their IQ tests are probably the most valid and reliable tests that psychologists have at their disposal. An IQ test can tell you with a high degree of precision and reliability what somebody's intellectual capacity is, and there is a particular score, there's a particular diagnosis, and a psychologist can say the person meets this diagnostic criteria or they don't. If they meet it, then the U.S. Supreme Court says the person's ineligible. So there, the psychological question and what a psychologist can do with a test is right on what the legal question is. In lots of other cases, what a psychologist can do and offer is much further away from what the legal system is asking. So for instance, in a child custody case, the legal system has to decide, the judge has to decide what's in the best interest of this child. There's all kinds of tests that psychologists can use. They can do personality assessments of the parents. They can do IQ assessments of the kid. They can do all kinds of things to speak to which parent is in the best interest of this child, or who has better parenting capacities or something like that. But there's at least a dozen different kinds of questions that the legal system might ask a psychologist to help answer. Things like violence risk assessment to inform somebody's criminal sentence. The more violent they are, the more potentially violent they are, the more significant their violence might be, would increase a criminal sentence, or make somebody end up in a facility that is a tighter form of custody. I can't think of the right word. And many other different types of questions. If you're curious about this, in our paper, the first paragraph of the paper lays out a whole bunch of different questions that the legal system might turn to a psychologist to ask for help answering.
So you mentioned that these tests are expensive. Who pays for these tests in court cases when they're sold by for-profit companies?
Yeah, so initially the psychologist buys them, right? So they're marketed to the clinician, and the clinician uses their money to buy. And there's a lot of pieces that you have to buy sometimes. Sometimes you have to buy an administration manual, a scoring manual, the actual materials that a person might use. Oh, I was going to say, in response to the previous question, there's a lot of ways in which these assessments are done too. So sometimes it's just a form you give to the evaluee, they fill it out like a true and false kind of thing. Or other times there are, the clinician will sit there with an administration book and have to say things in a certain way and ask questions in a certain way and then score what people are, however they respond, like what that means about that person. And so the psychologist has to buy those things up front and then recoup that cost in whatever they charge the person who's paying for the referral question, right? So it's usually an attorney or a court who's hiring the psychologist to answer whatever question they want answered. So that cost gets turned over. Also, in response to the previous question about which tools are better and which tools are worse, I was going to mention that projective tools are probably the least scientifically reliable and valid. There's definitely some controversy about that in the literature, but a projective test is, for example, the Rorschach ink blot test. So if you give somebody a stimuli and you say, what does this look like to you, or tell me what this could be, then the clinician would score whatever that person says to mean something about that person and infer something about that person and their parental capacity if it's a child custody case, or their violence risk if it's a sentencing hearing. So those are the most scientifically questionable, and we find strong evidence that they're definitely in use.
Another question in the back?
Yeah, this is a question also for Tess from Colin O'Connor with AAAS. He asks, are the assessments in your study only used by professional witnesses, or are they also used in state-ordered psychological evaluation?
They are used for all kinds of reasons. I don't know that I understand the distinction that you're making, Colin, but they can be used in forensic, in court context for all kinds of things. They can also be used in education settings. So for instance, if a teacher or a school system is trying to determine who's eligible for gifted and talented education or special education, a psychological test will be used to help make that determination. In employment settings, a lot of times there are psychological tests that are used for hiring decisions and so forth. So they're used in all kinds of ways. I don't know if that answers your question.
Another question in the front?
Well, I'm going to tell you about something happening in Egypt in the court. When they investigate a crime of a killing, they ask the eyewitness about the color of the clothes of the accused person, how many meters he was far from the victim. If these questions will be valid, yeah, because of the eyewitness cannot remember these details, the lawyer of the accused person can challenge his testimony. So this according to what you said about remembering the events and so on. So what do you think about these questions? When the court asks the eyewitness about it, is this a valid question?
Sure, I'll give a shot. And again, I'm going to give it it depends answer. Your distance and your ability to view the crime do matter. If you're further away and it's dark and you don't have a good look at the place, then your ability to describe what happened, to identify the perpetrator, is going to be severely impacted. And so if that's the goal, to assess whether or not the individual had a good view of the situation, then it can be a very reasonable set of questions. If the expectation is that if you don't remember the color of the shirt and you don't remember the way in which the person was standing, that you're a horrible witness, that's probably not a reasonable conclusion, because those are details related to the crime or related to the overall event that may not be particularly important aspects of the main questions, which the person may still nonetheless be able to provide evidence about, that we don't remember every detail from any event that we witness. Our mind does not work like a video recorder recording these sorts of things. We get pieces of it and unfortunately fill in gaps sometimes. And it's that balance that we are, as psychologists trying to look at eyewitness testimony, trying to evaluate it oftentimes.
Another question online, and then
Yes. This is another question from Nicholas Luco with El Mercurio for Dr. Neal. What is your opinion of the lie detector procedure as we see in films?
So the other panelists might have a good answer for this too. I will say the history of it's really interesting. So that when it first was trying to be admitted to court, the person who was trying to bring it to court was definitely a credible scientist, had a background in physiology and biology, I think, but it was a psychologist who was measuring differences in people's physiological reactions when they were lying versus telling the truth, and then was trying to infer from those things, was trying to infer from those things whether you could use measurements like that to determine whether a given person, given their own physiological reactivity, whether they were lying or not. So there was sort of a leap there in what he was able to do and what he was trying to do with the court. So when he brought it to court to say, I want to use this in a legal case to make a decision for court, for you to make a decision, I think this was 1923. It was Fry versus United States. That was the case in which the law decided we need to have some way to determine whether something is junk science versus not. That was the case that started all of this. And the judge in that situation, in that case, decided that the way to screen evidence was whether it was generally accepted in the field. So this was a new technique that the scientists had created. It was not very well known yet in psychology. So the court looked to other experts in that field to say, is this lie detector thing something that people are using? And at the time, the answer was no, and so the court said it's not admissible. That was the first time that they had these criteria for deciding whether something was valid or not. Now, I would say there's a lot of controversy. In a lot of legal settings, it's still not admissible, and yet it's in use in a lot of contexts. So the military, I know, uses the lie detector test for all kinds of things, and I would just say that there is some controversy still.
anyone want to add to that? Or okay, all right.
Good answer.
Okay. Another question in the corner.
Robert Frederick, American scientist. This question is for Dr. Hyman. Could you break out and give us some examples of some inappropriate questions and then better versions of those questions in terms of getting an eyewitness recollection?
Yeah, that's a really kind of fun question to try and take on, right? So, from my perspective, looking at the role of attention at this moment, I think that we need to start with doing an assessment of attention, asking questions about when did you become aware of this, and trying to avoid asking any questions from what would have happened before, which police will do anyway at this point, and so that there's a need, I think, to limit the questions to things that you had a shot at seeing, a chance to see. And even then, when you do start asking questions, the general advice is to start with open-ended questions. Tell me what you see, what you saw. Tell me what you remember. Do you have any other details? And to limit particular questions, and detailed questions to maybe follow-ups. But even then, it gets riskier the more you ask questions, and particularly any questions that might provide information. It's a way in which we introduce misinformation in our studies is by sliding it in as part of our question. You might have a different view on that, Sarah. I don't know.
Well, your question makes me think of like a finding I lecture on in my cognitive psychology class. It's a classic finding from Elizabeth Loftus. If you say, how fast was the car speeding when it passed the tree versus a tree? Is that the sentence?
No, the fun one there is one
the
of
barn, past the barn.
Right, yeah, but there's also how fast were the cars going when they hit each other versus smashed into each other, and just little, switches of the verbs matter. You get different estimates of speed. You get people adding in broken glass at the scene of the accident, and it's surprising how little it takes to get incorrect information out of people, which is why we're always better off with as open-ended of questions as we can possibly do. Yeah.
One of the fascinating things about the science of the study of questions is if I choose to ask you a question, I'm telling you I think you know the answer. Yeah. And in asking the question, so how was the buffet this morning? I imply that I have reason to think that you were there, and that in and of itself provides you with some information. A funny example from a friend of mine is, how's the food in prison? Implies a lot about what you think of them, right? And so. I think it's good to remember that the way you ask questions tells somebody something.
Other question in the front?
I'm Dahlia from Egypt. I work for Scientific American Arabic Edition. My question is for Dr. Sarah. You talked about the memory, and it's you can remember more what you said than what you heard. Is it a matter of concentration? Is it a matter of can we be trained to do the opposite, or is it reversible, or we cannot do anything? It's like that.
That's a really interesting question, and I don't know the answer. What we've observed in a lot of settings is in a different, like in recall tasks and recognition tasks, your memory is much better for what you said yourself. Why is that? One explanation, there's a class of explanations from the memory literature called the generation effects and the production effects that are very well replicated findings in a variety of paradigms that show this, and there's different theories as to why that is. Whether you could train someone to flip it, like if a trained person were to focus on the other person's speech, I have no idea, but it would be so interesting to know that answer. Sounds like a really good grant proposal. Thanks.
Are there ways outside of the use of the justice system, the idea that we can remember conversations to a certain degree and that provides evidence, if you will, or just a record? Are there ways that can be used in academic settings, our understanding of memory, or in informing couples who will get married, how much their spouse might remember about tasks you've laid out? Like, what are other usages of that?
Yeah, well, there's a lot of work showing that one term people use is that your memory of your experiences is egocentric, and it kind of has to be. It's from your own perspective. And so if you keep that in mind, if you're in a dispute with another person, keep in mind that each person had the experience from their own perspective. That could be a tool to work through a dispute with another person. One of my favorite examples, this is Ross and Sickley, I think it's 77. Oh, yeah. They went around to married student housing and asked them to estimate how much housework they did, and the total adds up to more than 100%. Or 78 maybe, but anyway, it's one of my favorite.
It's a good paper.
Good, yeah, favorite paper, yeah.
Awesome, okay. Well, if there aren't any other questions, thanks so much to our speakers. That was a very insightful briefing, and we appreciate your time. Thank you.